What are some of the common misconceptions that clients have? I'm Jim Gordon of Beers and Gordon. Let me explain some of the common misconceptions. The biggest misconception I think I see is every case is worth what you see on the billboards. That is probably the biggest mistake that clients make when they call. Those billboard cases involve catastrophic injuries, and more importantly, because we've had cases with catastrophic injuries where there's just not enough coverage. And so it's catastrophic injuries and a lot of coverage that covers for those catastrophic injuries. That's probably the biggest misconception I see. Another misconception that I see is that insurance companies are just going to pay to get out of the case. People will call and say, well, I know I'm not hurt that bad, or I fell at the business and I'm not sure what I fell on, but it's a company, it's Walmart, they'll just pay. That is so far from the truth that a company is just going to roll over and pay. I remember when I was a young attorney, they said they wanted an employment case against Disney. They wanted $100,000, and Disney makes so much money, they'll just pay. I said, if Disney paid everyone $100,000 and left, they'd be bankrupt in a couple of years. Companies fight cases. Insurance companies fight cases. So they will fight the cases tooth and nail and not just roll over and pay, even a small settlement sometimes. My first trial I went to trial over was $500. The case went to trial over $500. The plaintiff wanted $5,000. The defense wanted to pay $4,500. My client was actually a lower level defendant, and we got dragged into a 4-day trial over $500. So my point on that is, I've seen insurance companies spend many multiples of what the case would be worth to try it instead of paying it. Another common misconception is what jurors get to know. So that is one of the hardest things to explain to clients. One of the biggest things they ask is, well, they have insurance. Well, I want them to know that this person has $100,000 worth of insurance. The word insurance never gets raised at trial. If you're suing an individual or even a company, unless you're suing an insurance company. But otherwise, if you're just suing an individual in like a car accident case, they never get to know, the juror never gets to know, is there insurance and how much insurance is there? In fact, I would say in almost every case I've had, jurors get to ask questions. And one of the questions that comes up in almost every single case at some point in the trial is a juror question, handwritten question saying, where's the insurance company, or how much insurance is it? And the judge doesn't get to answer that question. In fact, the judge actually says, there are certain questions based on rules of evidence we're not allowed to answer, so I can't answer that question. But a lot of people think, well, they're gonna know that it's $100,000 in coverage, so they're gonna give me $100,000. Jurors don't get to know that. It's what's called the non-joinder statute, and jurors don't get to know about that. Another misconception is about PIP insurance. People think, I'm not at fault for the crash. Why is my insurance company paying for my treatment? That's the way the Florida system's been set up for over 50 years. And we're one of the few states that still has this system, but it's set up that no matter who's at fault, your insurance company is going to pay the first $10,000 of medical treatment. It's paid at 80%. It's a formula. It's double the Medicare rate, paid at 80% and leaving you the 20% balance. But clients get very frustrated and say, why is my insurance company paying? I don't want my insurance company to pay. Tell my insurance company not to pay. And I have to explain to them in each and every case, that's not the way the law works. PIP is paid, and it's called primary insurance, and it has to be paid first before anything else will kick in. Another misconception is that the insurance is going to pay as they go, meaning the other side's insurance, well, that they're just going to keep paying my 20%, that PIP's not paying, and they're just going to keep reimbursing me as I go. That's not the way it works. You get a one-time settlement. When you settle a case, your attorney settles the case on your behalf. It'll be that payment and that's it. It'll be a full and final settlement of any and all claims, past, present, future. So they don't keep paying as you go. And sometimes clients will even ask, well, can we keep it open? Like, I want to keep it open in case I need a surgery or in case I need more chiropractic treatment. I'll take this amount of money, but I want them to keep paying treatment. That's not what happens. Defendants want finality. That's why they're paying. If they're going to get finality, if they go to trial, because at trial, the jury cannot award future medical expenses to be paid as you want them to be paid, as you may need them, as you think. They actually have to give an amount. So we have to go in front of the jury and say, this person needs $100,000 in future medical care based on these opinions of the doctors. So people tend to think, well, I just want to keep it open. The finality is important. That's why cases settle. Are tickets going to come into evidence? That's a common misconception. A ticket determined by an officer, a police officer, who wasn't at the scene, who's just relying on the statements that you gave and the statements that the other person gave. That ticket and that determination by that officer is not coming in, good, bad, or otherwise, in your case. I have clients all the time that say, I want to use that ticket because that proves that they're at fault. I can't use that ticket. It's called the accident report privilege. I can't bring that up in court. On the flip side, I've had clients be given a ticket and I'm looking at the case and I'm like, this should not have been a ticket. You didn't do anything wrong and I can prove it. And I tell them, don't worry about the ticket, just pay it, be done with it, because it's not coming into evidence. But it does frustrate clients because they say, well, the officer determined it, why is it not coming into evidence? And I have to explain, you cannot substitute the determination of the jury for the officer's determination. A common misconception is how quickly personal injury cases go. A lot of times clients will say, I just want this case to be over in a few months. The problem is, we don't know when that settlement, or if it goes to trial, it's going to be a really long time, 18 months to 2 years, but even a settlement, when that's actually going to take place. It's dependent on many factors, but probably the biggest factor is how long you need treatment. That is probably the number one factor, because you may need treatment for several months, or even sometimes people go for 6 months or a year and then they decide, I just am not getting better and I'm going to go have surgery. Your attorney should not be making a demand, especially if there's enough coverage for your injuries, until you've completed that treatment, because what you don't want to do is settle a case, for example, as a non-surgical case and get a certain amount of money and then turn around 6 months later and have surgery, because you can't go back and reopen that case and say, oh, by the way, I had surgery, I want double, triple, quadruple what I got because I had this surgery. So you want your attorney, and at Beers & Gordon, we wait until all of the treatment is done, all the future treatment we think is going to be done, and that's when you make the demand. So it can take many weeks, usually several months. I tell clients 6 to 8 months is kind of the standard. If your case ends up in trial, we're talking 18 months to 2 years from the time we file until the time we actually get it to trial.